porches. At the last meeting, the update was provided that the association's contractor did provide and install temporary shoring to address the front walkways and the back patios. That was consistent with the engineer's specifications and draw-up, and then the engineer inspected that and confirmed that that was sufficient. So the immediate unsafe condition issue had been addressed as of last meeting. Those supports remain in place. Since we were last before the board, you'll recall that the association, as to the broader project to have the permanent, more long-term fix to the building, was attempting to secure financing so that they could move forward with the project. I'm pleased to report that they have secured financing. They did go through with their lender. They've closed on that, so they have the funds to move forward with the project. At that point, contract negotiations started with the contractor, which is Suncoast Restoration and Waterproofing LLC. Those contract negotiations, there was quite a bit of back and forth, frankly. As of this past week, Thursday or Friday, we got the email from their rep that they've agreed to all substantive terms in that contract, but Suncoast needed to revise the scope of work listed in the contract and submit that back to us before we could all sign off. So I was hoping to have that, frankly, before I walked in here today. We haven't received it from Suncoast, but we're waiting on them to do their final part before everybody can put pen to paper. So final stages of the contract, we have financing in place. Hopefully everybody puts pen to paper here very shortly, and permit applications are submitted to the city. I know when we last met, the board was hoping that permit applications would have been submitted before I came back before you today. Unfortunately, that's not the case because of the length of time of these contract negotiations. But I would submit to the board that, again, one, we're very close to that point, and hope to be there very shortly. In addition, the association has done all that they could possibly be asked to do unilaterally. I mean, the only thing that has slowed them down is waiting on third parties, waiting on the engineer to generate the initial contract, waiting on Suncoast to develop the scope of work and do their internal process as part of the negotiations with this contract. So the last thing I'll add is that the association also, since we last met, they've taken it upon themselves to engage SEI, who's the contractor they've been working with throughout, to inspect all 27 other buildings in the community. As SEI is finding problems, they are addressing those with a different contractor than Suncoast, but addressing those problems. So they've gone to take that step as well. So they're doing all they can to protect the community, all 28 buildings, to address this building in particular. But I would ask the board for 30 additional days. Again, I know the board wanted to see applications by this point. It's not the association who slowed this down. They want to see it done as much as anybody. We're right at the finish line. And I think if granted 30 days, my hope and expectation would be that I come back before you and let you know we have a signed contract and application submitted to the city. I think fines at this point, candidly, would be money that the association doesn't have for this project, but also for the additional inspections on the 27 other buildings and repairs there. So again, we'd ask for a 30-day extension, recognizing that we were granted that extension in April, and that the board had hoped, again, that we'd have these applications, but it's moving forward. We're right there.
We agree, and we appreciate that update. I think that was our main concern. But I think the fines were not scheduled to start until August, right? Correct?
I believe the topic was to be revisited today, depending on this update, if I recall correctly.
Oh, if we were going to, okay. So do we want to make a motion on this, or we just want to do another extension?
You could, if the board wants to, we can just move this to next meeting for an update. If the board is unhappy with the update, you can vote to impose a fine.
Okay. I make a motion to move it continue it to the next board meeting.
Yeah, you're going to be here for the
second.
following.
Yeah.
Yes,
This discussion of the motion. Who's inspecting Suncoast's work? Do we have an inspector for that?
there is. It's Karen's Engineering. They developed the initial scope of work. They prepared the initial contract draft for this project. They will be overseeing, and they've been engaged by the association to oversee Suncoast's work.
Right.
SEI has been involved in, that's the engineering firm that's dealt with everything up and until the project starts.
Right. And what's the estimated cost of this work? Do you know?
The larger project, it was in the ballpark of $500,000. I don't remember the exact figure. But they got 4 bids, they were all within that range, it was right in that range.
Okay, that's all I have.
Yeah. Good with extending. Sorry, did you second that?
Do you,
Second.
do you want to hear from the city if there's anything more to be added?
Sure.
I don't know if they want to, but,
No, 30 days would be fine.
okay.
Or
Thank you.
Next board meeting.
Yeah, we'd appreciate another status update at the time. It sounds
Absolutely.
like you're making a lot of good progress.
Thank you very much, members of the board.
Okay. So all in favor?
Aye.
Aye. Aye, for the extension. Then we'll delay fine, or making a motion on fines until then. Thank you, Mr.
Thank you.
Cantrell. Okay, item 4.2, also continued from April. Oh, it looks like we're continuing this one to the 26th. Okay.
Yeah, those are all
And
good.
item 4.3 is also continuing till next month, correct?
Yes.
Okay, moving on. Item 4.4 has been withdrawn. Item 4.5 is case 48-22, fines respondents Beverly, Scado at 1913 Kohls Road in violation of code for exterior surfaces and roof maintenance. Is there anyone here to speak to this case?
Where are we?
Hi, please step to the podium and state your name and address for the reporter.
Beverly, Scado, 1913 Kohl's Road.
Do you admit the violation, Ms. Scado?
Yeah, well, yeah, I'm in the process of selling the place, and I'll probably need another 30 days to be able to have it all taken care of, because I don't know how long they're going to take.
Okay. Do you guys want to make a motion, or you want to hear from her now?
Do you want to do the first
Yeah.
motion? It's a
I should say
submission.
move to
We're gonna
find the
take that
res-
as an admission.
Yeah, we'll do the first motion. I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I'll second.
All in favor?
Aye.
Okay, so can you tell us a little bit about what your plans are? You're working with Mr. Dixon on this?
I'm sorry?
You're working with Mr. Dixon on this
Mhm.
case?
Yeah, I'm more than likely going to sell the house, and then they're going to fix the windows and stuff.
Okay.
And I don't have any plans after that.
So your intention is not to do these repairs before you sell the house, correct?
Correct. They're buying it as is.
Oh, you have a buyer for it already?
Yeah.
Okay, so you're,
I'm just one signature away from selling it.
when is closing? When do you?
August 20th.
August 20th, okay. Do you mind if we hear from the city?
No.
Okay, we're going to hear from them and then make a decision.
Good afternoon, Board. I'm Inspector Gregory Dixon. This is case 48-22 for 1913 Kohls Road. There's 2 violations at the property, one in violation of Code Section 3-1502B for exterior surfaces, and Section 3-1502D1 and D3 for roof maintenance and a clean roof. Notice of violation was mailed on March 7th with a compliance date of April 7th of this year, and the certified mail receipt was received back in the office on March 22nd.
Something is,
Hold on, we can't see you.
Yeah, we can't see his.
they were working on this before the meeting.
Is it here?
It's,
No,
no, it's not even there.
we have a blue screen.
It's okay, I guess.
Can use the projector if you want.
Yes, that'd be perfect.
I'm sorry, you said it was received in May?
No, I mailed the notice of violation on
Oh, Mark.
March 7th. And I received the green cards that they signed for the mail on March 22nd.
She's got you on this side right now. The projector.
Which one are you using? That one?
Yep. They're not getting it there?
That's this. I mean,
Yeah, no,
okay.
it's not.
They're not
coming on
doing
the
it.
podium.
Oh.
There's something wrong with it.
It was there a minute ago.
Is there just a second?
We can turn around.
I was gonna say, if you don't mind turning around, it is on the ones behind you.
There we
Oh,
go.
there it is.
There it is. Okay.
The projector's here, right?
Yes.
All right, here's some photos of a, kind of hard to see there. Can you zoom in?
Heavily overgrown.
I think that's trash.
So the debris that you can see in the driveway is a separate issue that we're dealing with. This is just for the exterior of the home. And there was a tarp that was on the roof. It's been removed, but there's still some debris on the roof and on the back side of the house. There was some construction that was attempted, so the back side of the roof needs in repair. It's in need of repair. These are hard to see, but there's mold, mildew, peeling, failing paint. It's on the back side of the roof that needs repairs. That is a picture of the tarp. You can't hardly see it, but there's a picture of the, I guess that'd be the south side of the building. North side. Do you want us to try to see any more pictures?
Yes. What are your recommendations, Mr. Dixon?
So recommendations for case 48-22 for the 2 violations of exterior surfaces and roof maintenance is I request compliance on or before September 1st, 2022, or a fine of $150 per day per violation if compliance is not met. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And compliance can be met for the exterior surfaces by repairing all damaged exterior surfaces, remove any mold or mildew, and repaint the house where needed. Compliance can be met for the roof maintenance and a clean roof by removing all foreign material from the roof and make necessary repairs to any damaged areas of the roof.
Thank you.
I have a question. I don't know if it would be directly for you or for Sky Manager, but obviously if she's saying that the house is going to close on the 20th, whomever buys it is basically inheriting this situation. Is there something that would happen during the sale that would then be provided to the new owner to be aware of this and then the timeline to get it done?
Well, there haven't been any fines imposed on these cases just yet. If there
Right.
had been, then she could enter into a stipulation agreement where we can work with those fines
Okay.
as long as A, B, and C happens within a certain time frame. But
Okay.
there are some liens that will have to be remedied for nuisance abatement on
Okay.
the property.
I would just hate to see the new owner all of a sudden, September 1st, we've said, okay, by September 1st, you need to have this done, and then,
This particular violation wouldn't transfer to that owner, in my opinion. So what would happen is he would need to renotice the new owner if it's not remedied by a certain amount of time, and we would start this process with the new owner again.
Okay.
The liens that are previously on the property, unrelated to this, will need to be handled before the property transitions
Okay.
owners. But this particular violation is directed towards her as the property owner and would not transfer with.
Right. We wouldn't have the lien in place for the time period before the transfer.
okay, got it.
So this is essentially, in my opinion, would be in the abundance of caution if the sale doesn't go through, she still has the obligation to correct this violation.
So you may want to set it for the August, you may want to decide what you want to do and then set it for the August meeting.
I think that would make more
Apologize.
sense. This is
Yeah, it is. Do we have any proof that this property is actually being sold? And who's this?
Excuse me, I hate to interrupt in the middle of things. My name's Rogers Hayden.
I'm sorry, were you sworn in?
No.
confirmed to tell the truth throughout your entire testimony?
I do. And I'm here as a concerned citizen, and the fact that Beverly has worked for us for 20 years. And, mainly the issues with the house stem from being able to afford the repairs, perhaps some hard-headedness. But I've been in here listening, and I can't hear a thing. So but I'm looking at the dates up there, and I was under the impression that the house just needed 2 or 3 windows replaced, and it would be fine. Apparently, that's not the case. I'm reading something that says, and I saw the pictures, that the entire exterior needs to be improved, remove the mold, patch the broken stucco, repaint it, etc. There are only 2 solutions for this situation. I don't think the city wants to be in the position of foreclosing it for a small amount of fines, and that's not a very good solution anyway. It makes nobody very happy. But I also happen to be a certified general contractor, and I know how to fix things. And if it's going to get fixed, I'm also going to be paying for it. And we're in a situation where it's hard to get people to do certain jobs, and jobs like this are the worst kind for performance because they're small and difficult to get qualified people for them. So she's had some significant offers just to buy the property. That would be a solution for her. But the better solution is to repair the property and continue to live there, but repair it properly and get out of violation. The only suggestion I'm making, looking at these numbers, is that's going to be hard to do by September 1.
Who lives in the house now?
Nobody. She owns it and would live there, except she cannot because also, and I don't know who did it, code enforcement must, but they also had Florida Duke Energy remove the electric meter. So the house has no electric power right now either.
Are you a potential buyer?
No, I'm a potential person to pay to fix it up.
You have a great deal.
But I've got to go up there and look at it. I just found out about this a short time ago, and so I wanted to appear here today to get the full scope of the issue myself rather than secondhand, and I'd like to be part of the solution and not part of the problem, but timing-wise, it wasn't going to happen by September 1st, and I understand it's ongoing. It didn't just appear yesterday for you guys, but it only appeared there recently for me.
Beverly, will you step to the podium? What is your intention with this uninhabited house that does not have an electric meter?
I have electric, but the reason why I don't have windows is because the police came to my house and pulled my windows out.
I'm not sure from these small pictures that this issue is even about the windows. Your letter should have detailed exactly what needed to be fixed from the letter from March.
Yeah, I don't recall getting a letter in March about my roof.
The evidence says somebody signed for it.
Maybe one of your tenants.
Yeah, maybe. Yeah, that was news to me. I thought it was the windows and the roof where it was leaking. My son attempted to put a overhang over where my washer and dryer are, and I said, no, you can't be doing that. You got to get a permit first, yada, yada, yada. So he tore it back down, and he did not fix what he tore out. And that's the area in the back there.
But no one can use the washer and dryer. There's no power to this house.
Yeah, no.
Yeah, so
No, that's...
we're just inviting more problems and more problems and more problems, leaving this house
I don't want any more problems.
unattended. So it's your intention to get rid of the house?
Yes, him and I are kicking it around because I don't know. Yeah, more than likely. I haven't signed it yet because I wanted to wait until after the meeting to find out what my options are here,
Okay.
and then go from
So
there.
we're not really considering setting this date further back, we're actually considering speeding it up because it looks like you're getting ready to sell the house, and there's no sense in giving more time for a house that doesn't even have electric, no one's gonna move into it, it's just gonna keep, this is just gonna keep going on and on.
Yeah, I don't even know what to say. So,
I mean, mind you, we're only talking about the exterior and roof at this point. We're not even talking about whatever other potential issues are going on with the property.
I don't know.
So if there's no intention to put money into it to get it fixed up, we might as well just, you get it sold so that it's out of your name. Otherwise, fines are gonna start accruing and,
Yeah, I don't want any fines. I would like the 30 days to figure everything out,
to
though.
make a decision.
Yeah.
Okay.
So that would be
Settle.
by the next meeting then.
Does anyone else have any questions for Ms. Scado?
When's the next meeting?
I think it's the end of August,
August
Are you
24th.
taking this, or are you gonna give her
24th.
my
Or-
recommendation of having it prepared by September 1st?
we're discussing.
Oh.
I think we'd stick with the recommendation, prepared by September 1st. Not until, or a week after.
August 24th.
August 24th, but the recommendation is for September 1st. So that would, push it into, we wouldn't be revisiting this case until the end of September.
Right, but the fines would be accruing if there was,
Well, the one issue is if she sells it by August 24th, then any fine, as already mentioned, would be irrelevant. So,
Might be
if
an
she hasn't
incentive.
sold it by August 24th, then any fine would go towards her, effective September 1st. So you may want to do your order and then we can just revisit, give you a status on the 24th, or you can hold the fine until the 24th.
Up to you. I don't think 6 days is gonna make a huge difference.
and just go with the motion for the 24th.
Make it,
I move to enter an order requiring the respondent to correct the violations on or before August 24th, 2022. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
is there a second?
A second.
All in favor?
Aye.
Okay, Beverly, so, hopefully it will all get resolved before the next meeting, otherwise we will probably see you back here. So I would just work with Mr. Dixon very closely to get all the boxes checked and get, everything cleaned up.
Okay.
Okay, thank you.
Thank you.
Thank you.
Thank you, sir. Item 46, case 49-22, finds respondent C&L Properties at 172 North Belcher Road in violation of code for exterior surfaces, roof maintenance, and exterior storage. Is there anyone here to speak to this case? Mr. Kasman.
Good afternoon, Board.
Hello.
Trying to get this centered. My name is Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. This is for case number 49-22 at 172 North Belcher Road. There are 3 violations here at this property for Code Section 3-1502, D1, D3, and D5 for roof maintenance, clean roof, and false roof elements. Code Section 3-1502, F1 and F2 for exterior storage non-residential, and Code Section 3-1502B for exterior surfaces. Notice of violation was sent on April 19th of 2022, and then again on May 20th of 2022. compliance date of May 19th, 2022, and then May 25th of 2022. Affidavit of posting was posted to the property at May 20th of 2022, and the notice of hearing was posted on July 15th of 2022. This is 172 North Belcher Road. You might have seen it if you've ever driven past the speedway at the corner of Belcher and Drew. It looks, I always thought it might have been abandoned in some form, but apparently there's a boys softball program that's run at that property.
Bullet softball.
I've
Yeah.
spoken with the man who runs it, Sean, who I guess was left in charge by the owner to take care of any issues at the property regarding the structure. This is on the north side of the property. There's a bunch of items stored outdoors. There's a tractor trailer, a small shed. There's actually a smaller property north here in between the speedway and in between this structure that is actually unincorporated Clearwater. It's handled by the county instead. As you see, there's some exterior plants growing on the building. Some items stored outdoors. There's other items stored outdoors on the premises.
But that first picture with the, is that a truck?
Yes, there's a tractor trailer. Like I said, there's 3 properties, 172 North Belcher, and then the property in between it and the speedway, which is actually a county property. And the dividing line is literally on that side of the tractor trailer. It's handled by the county and not the city.
Oh, but all this debris is on
Everything
the property.
this way,
Okay.
on the south side of the trailer, is part of the owner of 172 North Belcher. I've already spoken to the county and let them know about the property north, and they're sending someone over to take a look at that. So you could think of this palm tree also as a sort of divider line between both the properties there. There were some other items stored. As I went by the property, I noticed there was an archway with some damage to the exterior of the archway. On the south side of the property, there's items stored outdoors, plywood. Some of the windows are boarded up, and materials that aren't the corrugated steel are used to fill in gaps on the property. On the upper level there in the exterior, none of that wood is treated or painted, so it's really just rotting in the sun. This is a closer look at that archway that was damaged to it. It's a decorative arch. And then underneath, the soffits were failing underneath there, and there was, you could see all the exposed wood. But this way I went back in May. There was more items being stored outdoors. Apparently, there's 2 renters there, I believe, right now. One uses it for storage, the other is the softball, boys softball league. This is on the south side of the property again, still storage, still boarded up windows. I went by, these are just the pictures of each individual posting for each violation on the front door of the property. This is back on the 26th, after the compliance date, after everything was posted. There were the same issues with the property, the storage just comes and goes, it's changed out. Nothing's been done to fix the exterior. This was the posting for today's hearing on the 15th. That's what it looks like far away. I went back on the 25th. Still the same issues. I actually met out with Sean, who runs the boys softball, tried to understand what the owner was thinking and why they weren't doing anything. He said he was left in charge. I explained to him that if he was going to be pulling permits, he would need permission from the owner to do so, and they'd need to hire a contractor. They did do some demo work without permits, and there was a stop worker to put in at the property. They removed the archway.
Oh, okay, I understand.
So, same issues with outdoor storage.
Does he know who this CNL is? Is there a
We
human
finally
behind
figured
this?
out that it's the same gentleman who owns 2171 Drew Street. This is just another one of his properties. His name is Don Leonard. I got a hold of him recently and explained all the issues at the property and what had to happen there. He said he would take care of it. I said as long as they showed some work towards a solution, I would give them more time, but this is not the same. This is not the first time I've dealt with him on one of his properties. And him not signing for certified mail or getting contact with me. You
Does
guys
he
have
live
any
here?
further questions?
Does he live here?
Don Leonard, I don't know exactly where he lives. We came forth with his other property at 2171 Drew. It was the same issue. His tenant was keeping a bunch of stuff outdoors. He has a different name for each of it, sometimes for some of his properties. It's with CNL Properties Partnership rather than CNL Properties.
I was just curious if he was local. Okay, do I have a first motion on this?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
A second.
All in favor?
Aye.
And your recommendations?
Yes, for this case, for 49-22 for 172 North Belcher Road, requesting compliance on or before August 27th, 2022, or a fine of $150 per day per violation for each day the violations continue to exist. Asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met for the roof maintenance by repairing any damage to fascia, soffits, or other parts of the roof. Compliance can be met for exterior surfaces by cleaning and repairing all damage to the exterior structures while removing all non-conforming materials from the exterior.
And you're not asking for a permit for these to come into compliance. They just took it upon themselves to demolish that piece. That was something
I've
totally
spoken
different.
with Sean. There was other issues at the property with vehicles without stickers. I did end up towing his vehicle from the property
I was wondering why it was missing.
because he thought that what we were asking was for the vehicle to be cleaned. And I explained to him, no, we needed to have the tags, and my number was on there. And he said to me that he did not think it was necessary to call me to ask exactly what he had needed from me. But I've explained to him several times that the building is in dire need of some repairs, and he wouldn't give me the name of the owner. And then the owner finally got in contact with me. He was the same owner of 2171 Drew Street.
Okay.
So
I apologize for interrupting.
that's all right. And then compliance may be for exterior storage by properly storing or removing all pallets, construction materials, furniture, and any other miscellaneous items from the premises. So
Any other questions? Ma'am?
I move to enter a motion, an order requiring the respondent to correct the violations on or before August 27, 2022. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day each violation continues to exist, if the fines and fees remain unpaid, 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
A second.
All in favor?
Aye.
Aye, motion passes. Items 4.7 and 4.8 have been withdrawn. Thank you, Mr. Kessler. Item 4.9, case 52-22, finds respondents Elia Ronchetti at 14 South Glenwood Avenue in violation of code for residential rental business tax receipt. Is there anyone here to speak on this case? Mr. Kessler.
apologize, board. This might be a little more difficult to see than usual.
Have we tried to reboot since it's up and running now? We tried to switch back over to the PowerPoint?
I don't know if I have control of that. That's-
Oh, okay.
Madam Chairman, IT is here. If we want to take a short break to allow them to see if they can fix the issue.
All in favor?
Aye.
To order. Case 52-22 continued. Mr. Kasman.
All right, excellent. Hello again. Daniel Gasman, Code Enforcement Inspector for the City of Clearwater. This is 414 South Glenwood Avenue, case number 52-22. There's one violation here for Code Section 3-2302 for residential rental business tax receipt. A notice of violation was sent on March 1st of 2022 with a compliance date of April 1st of 2022. The certified mail receipt was received on March 16th of 2022, and the notice of hearing was posted to the property at July 15th, 2022. This is 14 South Glenwood Avenue. There were a few issues at the property when I officially came up. There was an exterior surface issue and a grass parking issue. After checking the records, I had seen that there was no business tax receipt applied for, and the owner, Elia, lives in Pennsylvania, I believe. I did contact him and explain that he did have to get a business tax receipt for the rental at that property, and he said that he would take care of it. That was back in March 1st. This is the screenshot at the bottom corner, has the date and time. I checked the utilities. He's currently renting it to a man named Mark Stout, who I've also spoken with about a few of the other issues at the property, but those were taken care of. The only thing that remains is Elia getting the business tax receipt. This was in May 3rd. I checked our seller system. He still had not applied for a business tax receipt. He had not sent anything in. He's still renting the property out to his tenant. This is the posting at the property. Elia called me again and asked me about the business tax receipt. I explained it, how he had to apply for it. I offered to mail him a application again. He said he would get one of his family members to help him because he says that he's computer illiterate. So hopefully that's taken care of soon.
No grass
I
parking.
checked again on yesterday and he still has not applied, and he still is renting out to his tenant. Any questions?
Any questions?
Yeah, so he doesn't have a tax business receipt, correct?
Yes.
So when you tell him he needs to get one, what's the cost of getting it?
$31.50 a year.
Okay, but if he doesn't have one and he's cited and then goes in to get one, is it still $31?
Still $31.50 a year. The business tax receipt for the residential rentals, there's a nominal charge, but it also provides us a contact for the owner if there's any issues at the property, so we don't have to hunt them down through utilities or any other means, like when they finally call us after we post a notice of hearing at their property.
Well, they should be paying more for, once they get cited, it seems to me.
Well, we'll hear his recommendations.
We're more for compliance than punishment here. But,
Is there a first motion on this case?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
A second.
All in favor?
Aye.
Aye. And your recommendations, Mr.
yeah,
Bates?
recommendations for 14 South Glenwood, case number 52-22 for residential rental business tax receipt, requesting compliance on or before August 27th of 2022, or a fine of $150 per day per violation for each day the violations continue to exist. We're asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met for the residential rental business tax receipt by obtaining a business tax receipt for the residential rental or by ceasing to rent the property.
I have a question. Sorry. So, does he have the $150 per day, would that go back to when he was first cited?
When in this case, when our requests for compliance are before a certain date, after that date has passed, the code inspector can file an affidavit of noncompliance, and that has to be heard at a future meeting and accepted, and then the fines will go retroactive to this date that we are speaking of right here, which would be August 27th.
But
But you would have to be
Right.
accepted first.
the other, what you're asking for occurs in a repeat violation.
Any other questions for Mr. Kasman?
I move to enter an order requiring the respondent to correct the violations on or before August 27th, 2022. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
A second.
All in favor?
Aye.
Aye. Motion passes. Thank you, Mr. Kasman.
Thank you, board.
Item 410 has been withdrawn. Item 411 is continued to August. Item 412 has been withdrawn. Item 413, case 56-22, finds respondents Canal Jane at 3277 Beaver Drive in repeat violation of code for short-term rental. Is there anyone here to speak to this case? Hello, Miss Mulder. Okay, if you would please step forward.
These are the ones that own property, 3277.
The owner, would you step forward, state your name and address?
Kunal Jain, address for the violation property.
No, your address.
My address 6 Copperwood Court, Safety Harbor. Florida.
And the other parties, you can have a seat, Mr. Jane, thank you. Hello, please state your name and address for the recorder.
Brent and Danielle Hall, 2575 Elderberry Drive.
Okay, thank you. You can have a seat. And since there are multiple parties, we'll just let you start, Ms. Mulder.
Okay, thank you. My name is Rebecca Mulder. I'm the Code Enforcement Manager for the City of Clearwater. I'm presenting 3277 Beaver Drive, case number 56-22. There's one code violation, a repeat violation of code section 1-104B for a development code violation, as well as 3-919 prima facie evidence of certain uses in residential zoning districts, renting a property short-term less than the 30 days or one calendar.
Just jar our memory on this before we take a motion.
Okay. This is I'll go through the date when it was heard previously.
Please.
In the slide. Repeat violation, definition, do you need me to read that, or you guys?
That's not necessary.
I did my affidavit of posting on 5/27/22. Certified mail was received back on 6/7/22. This was originally brought before the Code Board on 7/28/2021 for an illegal short-term rental and was found in violation through a declaration. They came into compliance prior to, but they did do a declaration, so this time would be a repeat violation.
I'm sorry, I feel like we saw this case in 2022, though. Maybe, are you getting there, I think?
No, it was 2021. Julie Phillips presented this case. Both parties did appear previously as well, and presented presented information on why it was renting as well.
Okay.
So, and that they were in compliance, the neighbors' issues with the property as well as the
Right.
owners.
I believe that was February or March of this year.
We were here
Oh.
for this case this year, I know.
Oh, sorry, I might have put the wrong date. So since that time, I did receive additional phone calls from the neighbor saying that it was continuing to rent. The website did still, on most occasions when I would look it up, still set the compliant dates of the one calendar month. I checked back periodically and did observe on one date that, if you can see that I was able to book it for 16 days stay. So that is what I'm presenting for the one-day violation. Since that time, they have come back into compliance. I haven't been able to duplicate this, but because of the repeat violation, I'm looking for the one-time fine.
So just so the board understands, it's one day that you're asking for on the repeat violation because of what was found on the internet site?
Correct.
Okay.
And then, can we hear your recommendation first, and then we're going to speak to the owner really quickly?
So the recommendation, because they are in compliance now, I'm just requesting the fine of $500 per day for the violation, which was the one time, $500. No further actions.
Okay, and Mr. Jane, would you please? Hello, sir. I know we've been here before this year.
And I promised everybody that it's not going to happen. I tried my best. I have no idea how it happened. It happened, might be a technical glitch, because Sometimes you try different settings, different calendar dates. I don't know. I don't remember doing it by myself, but it clearly sees that it was there at some point of time when she was checking, it might have done.
Who's living in the house now?
Nobody last 20 days, or probably 10 days.
Who were the last people living in the house?
So, me and my wife, we own a company next to this rental property. We have about 20 employees here in Clearwater. We do training for physicians. The purpose of buying this property was that our physicians, they fly in from different places. We host them, we give them training, and they go back. Now, of course, it doesn't happen for long term, so people come for weekends or sometimes this. So my neighbor who is here had complained many times because whenever a smallest, even the noise which happens from our pool, they are oversensitive to it and they come and they complain. And I said, well, we are not running it as a business. But
you did have it listed on Airbnb. You have been
that
running it as a business.
Last year.
In May, she saw it.
May 2021. This May was a glitch. This May, what she saw, it was purely a glitch, which I'm accepting it might be because for last 3 months we have a monthly rental. We had a gentleman who stayed for a month. They probably know them because they go and interview each and everybody who comes there. So before that, we had a monthly rental, and if you have access to Airbnb, you can go and check when did we have the last review. That will give you an idea that our reviews, like we haven't had a review for last 4 months because we stopped using Airbnb.
I feel like when you have a tenant move out, then you relist the house on Airbnb and then you pull the listing again.
So if it would have happened, we would have reviews on Airbnb. We don't have a reviews for last 1 year. Anybody can.
You can ask your tenant not to put a review on Airbnb.
We haven't used Airbnb for a year. You can call Airbnb. They call Airbnb.
We have proof that you use Airbnb.
They themselves called the Airbnb. They checked it. They can testimonial if Airbnb said that we rented through Airbnb in last 4 months. We haven't. We only started doing Zillow. Zillow is monthly. I mean, I'm not supposed to give you that thing, but I'm telling you, we started using Zillow. We do only monthly rentals if something comes. Other than that, this is a technical glitch. I don't mind paying $500, but honestly, this was not done
So just so we're clear for the board, you agree that there was a violation on that one day?
No, I don't agree to that. That's a violation. I said it's a technical glitch.
Technical glitch, it was advertised for less than 30 days.
Well, then it does not have my address on it, does it?
I'm asking you if you're admitting to the violation.
Well, I don't think so. Because I did not rent it. I did not rent that place.
It's not what is necessary under the code. The code says
The code is
if it's
advertised.
advertised for less than 30 days.
It might be a technical glitch. I'm sorry. I mean, that's all I can say. I mean, because. Yeah.
I'm just trying to clarify if you're admitting this to the board, or the board needs to make a formal finding that on that day, the advertisement was incorrect.
Well, yes, but my question is, it does not advertise my address. So if it doesn't advertise my address, technically, it's not my advertisement, unless it advertises my address.
Okay, so you're not admitting to it, that's just what I want
If you want to go by rule, I mean, it has to advertise my address, or the advertisement has to be in front of my home. We have no advertisements there, and this advertisement technically does not have my address on it. But yes, I mean, if you want to fine me for $500, it's okay, but all I'm saying in sincere thing, I'm not doing that anymore.
But you are listing the house on Zillow on another site for rental.
Zillow, for 30 days. 30 days I'm
30
allowed.
days or more.
Yeah.
Do you charge your trainees to stay in that house?
No. It's just our company. If they come, it's a part of our solution and services, what we offer to the doctors.
What is the trainage? What are you training?
We do medical. We have a medical software. It's a medical EMR software. So they come for the trainings.
Okay. Are there any other questions for Mr. Jane? No. Let's hear from the other party. They've come all this way.
You can turn off the reviews on those, so he wouldn't.
Good afternoon.
There's lots
Like I
of,
said, thank you for taking the time. I'm exhausted by this. I'm not sensitive. We have huge dogs on either side of us. We are very, very friendly with our neighbors. We lived in this house for 20 years. He moved in and turned it into Shepherd's Spring Break, Clearwater Beach. So loud, horrendous, obnoxious rap music. When my children have autism, we work from home. I homeschool my children. These things are happening in the afternoon. I spoke with Councilwoman Texera. She recommended we contact the police. It's the afternoon. I'm taking resources away from police, number one, to deal with the situation. We asked him very kindly. We have been very kind with this man. He texted my husband, calling him horrible names like a schoolyard bully, threatened to sue us for being good neighbors before calling the police. We can't actually go on his property, so we just kind of, hi, over the fence.
I remember the text message exchange from when he was previously.
Kind, very trying to work, because we do have a lovely, beautiful, peaceful neighborhood where everybody does. We have little block parties on holidays and things like that. He moved in and turned it into a nightmare situation for everybody. My neighbors couldn't show up because they had work and child care obligations, but somebody's got to help us, because the second, it's like he'll have a long-term rental in there, and that's fine. They're quiet, no big deal. The second, he gets a chance, there's somebody in there for a weekend, having a party, and it's not us being sensitive, we're just trying to live in our home in a reasonable amount of peace. So that's all we really have to say, is that we just need help. We've tried to communicate with him. We've tried to make this situation work. He says we're being overly sensitive. We just need help.
Thank you
for our home, so thank you.
Is there, to your knowledge, is there someone living there now?
No, it's been pretty quiet, actually.
It's the short-term tenants that are the issue. It's not the physicians.
No. We actually, there was one lovely couple, there was one family there with, we brought them some of our bananas, because we knew they had kids. They were so sweet playing in the pool and stuff. So, we brought them over some of our bananas. Because that's just the neighborhood that we live in. We share stuff with each other. We, watch each other's dogs, things like that. So, we really did try to reach out. We're trying to reach out to these people, not harass, or we're just a friendly neighborhood. That's just what we are. So thank you.
Do you notice more long-term 30-day rentals in there than you do the short terms?
No.
You need to just come up so you can.
He's had 3 long-term rentals, one for a couple months, the others for a month each. Every other rentals have been a weekend or a week. I don't even think there's been.
He says the house has not been occupied in the past 4 months. Do you agree with that?
No. He did have it 1 month.
I'm sorry.
One at a time, please.
No.
No. He had a 1 month renter just recently.
Just recently.
Prior to that, he had several weekend renters.
Well, that's nothing. We drive by the house. We see it all the time. You know what I mean?
And we can tell within about an hour of them getting here whether they're long-term or short-term.
Yeah.
It's very easy,
It's
right?
very
I mean,
simple.
they either go back, hit the pool, turn up the radio, pull out the drinks at the tiki bar, or they're, calm, whatever. The first day in the pool, the kids might be a little crazy or whatever, because that's,
It's a pool.
but
It's
after
new.
2 or 3 days,
It settles down.
it settles
It's
down and
fine.
everything's fine.
Yeah.
But when it's a short-term rental, it's every single day, starts around noon.
And we can't
Yeah.
ask them. We've gone over and been like, can you mind turn it
Yeah.
down? And they'll turn it down for 20 minutes, and then it's cranked it right back up again. Because we're not going to be there that long.
Sure.
So the last time that I was here, 2 weeks later,
We got a notice from his attorney threatening to sue us.
for $30,000. Because
For asking for a motorcome. I mean, who does that? I've never in my life threatened to sue us for, I just can't even believe it. That's a neighbor. That's a neighbor for you right there. 20 years.
So, I've talked to, the staff, at this point in time, the only thing that I can see is that he needs to have his license, as far as tax license revoked, so he can no longer rent this. I mean, he's obviously has no interest whatsoever in abiding by the codes or the rules. Every time the $1,500, I'll just pay it. He paid it. Well, that's a weekend, right? It's a weekend rental. It's a cost of doing business. Unfortunately, your codes are not written, they're written for people to come into compliance. They're not written for somebody that just wants to play the game and do, like they say, it changes all the time. Because if any of you have Airbnb, he has Airbnb, VRBOs too. He just recently went on Zillow, I guess, but those are short-term rentals. That's his intent. That's what he wants to do. This is about making money. It has nothing to do with anything else.
Yeah, the code is for the 30 days, so he is allowed to have
Well,
people in there a month or more, 30.
He has had 3 violations in a year. This is the 3rd time he is here with the same violation in a year. Because of technicality that you have it in the code that it has to be the permit year, he doesn't quite meet that. The A, there is the version as far as the 2941-1A that does provide that if you have, they allow a nuisance to be maintained at their premises in a constant violation of the code or actions to the neighbors, that code and the neighbors, it really is a consistent, what am I trying to say, nuisance. So I think the code does have language. It's very general, and I know the attorneys generally don't like the general language, and I appreciate that. But I would ask that either you revoke it or you put a notice, and you put him on notice that says next time he violates, that his tax receipt is removed, and so that he can no longer rent. I mean, he's fine. If he wants to abide by the code, we're fine with that.
Yes, absolutely.
And we don't have issues, we haven't had issues with any of the long term. The 3 that he's had in the last year. But the week renters, it's just too much. And then having to deal with, every time I ask somebody to be quiet, I get a text saying, I want to send my attorneys after you. It's ridiculous.
Yeah, it's unfortunate. Well, this is a repeat violation offense, so we're going to take all this into consideration. Thank you. Thanks for coming. I'm sorry, this is so draining. Mr. Jane, please.
With all due respect to the couple who lives in my neighborhood, I said the last time also, I don't want to create any trouble. They repeated the same story last time. This is an old story. He is again saying the 3 people in 2021. Since I was here last time, we have only monthly. There were 2 parties. They are my personal parties. One was my birthday party. One was my wife's birthday party. We bought this home. We can use it for our own self.
I want to clear something up. We're here because she found the offense in May. She found the house was listed for short term in May.
Right.
That's why we're here as a repeat. It's obvious to me that when your long-term tenants move out, you relist the house to get the next available tenant in, whether it's short-term or long-term.
Ma'am, they called Airbnb. We had a conference call. They denied the home was not rented through Airbnb.
This is not what this is about.
That's what you're saying, that I relisted on Airbnb. I didn't.
We have the
That was just
evidence.
one
She was
time.
allowed to book for 16 days.
That was one time when we
And
were,
that's what you're
when you
here
make
for.
changes sometimes, if I make change, just like we had a technical glitch just now 5 minutes ago. So you don't control those things. And that does not mean that it gets into the system and she got the reservation. The reservation was never made.
The code is for advertising. The code is not for whether or not she can make
So
the
I'm not
reservation, whether or
advertising
not she can
anymore.
stay there.
They have been just constantly threatening me with the same stories that we have dogs. We have nobody in that home for last 10 days. Last tenant lived there for 40 days. Before that, we had somebody who booked for 30 days, left within 15 days, not in my control. I have been constantly giving monthly rentals. We don't want to give such a beautiful home. I don't want to give that home to weekly or 2 days or 3 days. But I don't control if somebody books it for the 30 days, leaves in a week or 10 days or 20 days. I don't control it.
You have quite a few customers paying for 30 days and then leaving after 15.
We have stopped advertising less than 30 days completely. We don't even entertain them. Unless it is my personal party. That home is on the golf. I play golf. I have my friends. This last weekend I was there. And we had even put what did we do? Some noise meter. So we have put a noise meter there. So even if, there is any new noise from radio or whatever they are saying, it would alert. even if for 30 days people were staying. So I'm taking all the precautions I can take, but I'm also a citizen. I have a right to play and do the things at my own home. I just can't live on their mercy that they would come and come up with anything.
This fine is about short-term rental, not about anything else other than
Well,
the
it
short-term.
was about everything else what they have described, and that has an effect or impact on your decision. That's what counted, because that's what they have been talking about, that I'm creating nuisance for their lives. I'm not.
Okay, does anyone else have any questions for Mr. Jane?
No.
I want to resolve it too, permanently. I don't want to see my, come here again and again. So it's my intention.
I think so. I think we have a first motion. Ms. Mulder? My question is 500 the maximum on this violation?
Yes, I believe it
Yes,
is.
it is.
Are you aware of the other websites that he's advertising on now?
I do check VRBO and Airbnb regularly for all of our, anyone that has a declaration of violation, including this property. I was not aware that he was advertising on Zillow. I don't know if they do short-term rentals on there. I'll double check. But this was the only instance where I could have some means to verify to bring to you a violation outside of the claims from the neighbor.
All right, we appreciate that. Do you have any more questions? Okay. Can I get a motion? Do we have a first motion?
We do not have a
Can we
first
get a
motion.
first
I
motion?
move to find the respondent was in violation of the code as referred to in the affidavit in this case and has committed a repeat violation.
A second.
All in favor?
Aye.
Aye. And no other questions for Ms. Mulder before we enter an order?
I move to enter an order the fine of $500 for the 1 day the repeat violation existed for a total fine of $500 payable within, what do we do, 30 days?
30 days.
30 days. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose or collect or settle such lien. If the respondent repeats the violation, the board may order a fine up to $500 for each day that the violation continues to exist.
Second.
All in favor?
Aye.
Aye, motion passes.
Thank you.
So hopefully we won't see this back again
Hopefully
this
not.
year.
Hope not.
Thank you.
Thank you.
Thank you.
Thank you, everyone.
Just so the board's aware, continual repeat violations can result in an injunctive action by the city. So that's one of the things that they'll have if this continues on.
Who would begin that process?
The city would
Okay.
begin that process. It becomes a formal nuisance and/or a situation where an injunction would stop any further short-term rentals if there's continual repeat violation.
And don't we have a noise ordinance that they can, and I believe it's, if you create a noise beyond 100 feet from your property line, and I believe the police department handles that.
That is correct. And those violations also add to the point of getting to an injunctive action. So it's repeat violations, it's noise, it's other nuisances. Once that has become evident, then the city can look at that and determine whether they want to take action.
Okay. Hopefully all the parties have heard that and are listening. All right, number 4.14, case 62-22, finds respondents 1417 Cleveland LLC at 1417 Cleveland Street in repeat violation of code for permits. Is there anyone here to speak to this case? Hello, Ms. Espinosa.
Good afternoon, Board. So, let's see. Okay, I am here to present the case for 1417 Cleveland Street, Nilda Espinosa, Housing Inspector for the city. Let's see. It's a repeat violation. Stop work order was issued. Permit is required under Section 4-203.8.1 and Article, 4 under -47.083. We're commencing before permits issued. Notice of violation was sent in July 30th of last year. again in October 19th, 2021, and a final notice was sent on April of this year. Compliance was for 8/18/2021, November 18th, 2021, and final was May 18th of 2022. Certified mail was received on August 15th, 2021, October 27th, 2021, and May 9th, 2022. Sorry. Notice of hearing was sent out with the final notice of violation, which was in April 28, 2022. And certified mail was returned in August 5th of 2021, October 27, 2021, and May 9th of 2022. Inspector Sam Swinton bought this property owner for commercial property. They enclosed the windows in the back. The board found them in violation, and that's the repeat violation definition. This is where the place is located. It's the strip mall. It's where the city is taking care of the street, putting in new sewer lines and all that.
Oh, I know where this is.
Yeah, it's going up the hill towards
From
Highland.
the laundromat, yeah.
This is where the violation is. You can see the blue arrow is 1417. It's a restaurant. Next door is 1415A. It's 2 suites. Fire department called me on this. They were doing an inspection. As you can see, this picture is from 1415A, and you can see a wall that's been opened up. This is from inside the unit 1417. They also put in a walk-in cooler. That's a walk-in cooler.
Nice.
I found this in archives. It's a microfiche showing all the units and the individual. You can see the walls between each unit. That's all.
And there's no one here to, have you talked to the owner?
I have talked last year to the people who, the company that owns it, and a contractor called me twice. I told him what was needed. I sent him a copy of the microfiche that I found showing individual units. Nothing.
Okay. Is the restaurant is not the owner?
It is, that's always been a Mexican restaurant as far as I know, way back. Don't know which business owner opened that. The property owner said that they were not aware that this had happened until I informed them.
Okay.
And again, fire department went out there to do an inspection, and they closed them down for a little bit because they found some issues under their codes. They are open again, a new restaurant, business owner again, so.
So just to dig a little deeper, this violation is not for the building owner.
It is, because they're responsible.
1417 Cleveland LLC owns that entire
Yes, ma'am.
strip mall. Okay, that was my confusion. But then each individual suite has a different address.
Yes.
Okay, gotcha. Yeah, do I have a motion on this? Any other questions for Ms. Espinosa? Can I get a motion?
I move to find the respondent was in violation to the code as referred to in the affidavit in this case, and has committed a repeat violation.
A second.
All in favor? Aye. And then your recommendations?
Okay, so for the one violation, repeat, it's compliance on or before August 31st, 2022, or a fine of $150 per day, and that's after 3 months of the recordation date of such lien. If the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
And just to clarify, we're asking them to get the permit for the hole, the opening, and the cooler. Okay,
Yes, ma'am.
alrighty. Is there a motion?
I move to enter an order to the fine of $150 per day be imposed for the, wait, is that the right way to say it?
Impose
I'm
for
on the right one,
the,
right? Do we know how many days is it?
how many days that violation existed?
Yeah, how many days it existed already?
Because this is a repeat, so.
Yeah, they have several businesses, and those businesses always have the address and then an LLC. I double-checked, Sunbiz, it's all owned by the same people.
But my question is for this board, is this a repeat violation for this particular infraction?
That's what we're trying to establish.
Oh, okay.
Well, if you look at the repeat information,
If it's a repeat violation, then each day that you observe the violation, you could ask the board to fine for each one of those days up to $500 per day.
I'll defer to Assistant Building Official Dana Root.
Yeah, we should change the recommendation to $150 per day, retroactive to finding the violation for 1417 Cleveland, because there was a violation of the same property owner at a different address. That's what makes it a violation.
Do we know how many days that was by chance?
Are we talking about
It
7?
started July 30th of 2021, so it's almost a year.
Let's just say 365 days.
360 days.
Let me ask, has this guy ever applied for a permit to do work there?
Not at this property, at the property that Inspector Swinton took them to. They applied for a permit to, for the windows that they enclosed in the back, also a commercial property.
Right.
It might be the tenants that have done this.
Ultimately, property owners are
No,
responsible.
I understand.
Yeah.
He can fix it if he wants to. Okay, I move to enter into order that a fine of $150 per day be imposed for the 360 days the repeat violation existed for a total fine of,
Do the math.
didn't know there'd be math involved.
$54,000, $150.
Yeah, $54,000 payable within 30 days if fees, fines, and remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien. If the respondent repeats the violation, the board may order a fine up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
I
I don't know. Motion passes. I don't know if we can submit it that.
don't know if it'll do any good.
I have a feeling we'll see them next.
I have a feeling too, because they came in pretty fast when they received the notice for the first violation. Thank you, board.
We appreciate
you.
it. Thank you. All right. Unfinished business. Can we lump the affidavits of compliance together? What's her name?
You could take those together, yes.
Okay. Case 917, case 2522, and case 3922, affidavits of compliance.
I move to accept the affidavits of compliance as listed.
I second.
All in favor?
Aye.
Moving on. Other action items. Item 7-1, case 60-22, accept the nuisance abatement lien for Respondents Veracity LLC at 1234 Eldridge Street for lot clearing. Mr. Dixon, is there anyone here to speak to this?
No.
Okay,
You want me to just go to the recommendation page?
please.
All right, this is case 60-22 for 1234 Eldridge Street. There's one violation at the property for overgrowth. And I'm requesting compliance 5 days after the board renders its order. If compliance is not met, I request an order be issued allowing the city to enter the property and abate the nuisance. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met by clearing all overgrowth and debris from the property. It's a vacant house that's about halfway through a renovation, I assume. I haven't seen anybody there for a while. I did have a local contact, but they no longer work for the company that's based out of California. And it was overgrown on 6/14, and there's been no change except the grass is just taller. This was a couple days ago.
No other questions? Okay. Yeah, please.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
A second?
All in favor? Aye, order passes. And item 7.2, case 61-22, accept the nuisance abatement lien for Respondent's Kohl FD Portfolio 7 LLC at 1835 North Highland Avenue for lot clearing dumpster / dumpster. I'm sorry, is there anyone here to speak on this?
No.
Okay, Mr. Dixon.
Gregory Dixon, Code Inspector for the City of Clearwater. This is for 1835 North Highland Avenue, case 61-22. There's one violation for accumulation of trash and debris. I'm requesting compliance 5 days after the board renders its order. If compliance is not met, request an order be issued allowing the city to enter the property and abate the nuisance. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met by clearing all trash and debris from the property. This is a Dollar Tree on Highland, and their dumpster enclosure is constantly full of trash that's not in the dumpsters that are just sitting right there. And we've had multiple inspectors go into the store and talk to multiple managers. So I posted the property on all over the place. And I sent a notice of violation. Corporate did call me. They assured me that the district manager would talk to the manager of the store and get it cleaned up. But it just gets worse and worse. And it's attracting homeless that are hanging out around the property.
This company hasn't responded to this Kohl FD portfolio?
Yeah, Dollar Tree's corporate headquarters
Oh,
called me and they said they'd take care of it, but that was 3 or 4 weeks ago. Nothing's happened except more trash is accumulated.
Okay. Any other questions for Mr. Dixon? Can I get an order?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
Aye, and order passes. Nothing else from the board? Mr.
One other
Salzman?
thing, just to remind board members, your Form 1, you need to fill it out, you need to get it in. It has a penalty if you don't, so we want to make sure that's your disclosure form,
Submitted yesterday.
please.
Okay.
That's it.
I don't know if he's looking at any of the guilty parties or
got
not.
mine.
I sent
Okay.
mine yesterday.
I sent mine in.
I now close this portion of the public hearing. Meeting adjourned.
Meeting adjourned.